All right. Hey, everybody. Welcome to tonight's seminar. Thank you for joining. This is a free seminar tonight about the expungement law, which is set to go into effect on July 12th of this year. So in a couple months, there's some new developments in expungement in terms of the rules that have been promulgated by the Supreme Court, petition forms, what the procedures are, and so forth. So today we're just going to go over the basics about expungement, give you an idea about what it is, how to petition for an expungement of your record, and what that means when you get it expunged, as well as talk about what your options will be to have someone try to help you to get the petition filed. So we'll do some questions and answers maybe 2 or 3 times through this thing. So you feel free to raise your hand, and there's a little hand icon down. You should see at the bottom of your screen. You can click that, and then we'll know that we should unmute you. And by way of introduction, my name's Tom Dean. I am Tom Dean, attorney for cannabis. I've been practicing law for about over 25 years now, and exclusively marijuana for many years, marijuana-related matters, primarily criminal defense, but also business as well. I was legal director for the National Organization for the Reform of Marijuana Laws back in the late 90s, and there in Washington, D.C. I'm a founding director of the Arizona Cannabis Bar Association, and have also worked with the Arizona Attorneys for Criminal Justice, as well as other organizations here in Arizona, in ACLU, for example, in helping with marijuana reform in key cases, appellate cases, as well as obviously working with any initiatives that we've had here over the years in trying to make sure that they include important language such as the expungement law that we're going to be talking about tonight. So I'm here with Kim. My assistant Kim is here, as well as Dave Wisniewski, Safer Dave, who is handling the media, film, the camera and the mic here. So thanks for you guys being here, and let's get started. So first of all, what I'd like to do is go over the statute itself. This is right out of Proposition 207, the Smart and Safe Arizona Act that passed in November. Right after it passed, cases that the kind of cases that will be eligible for expungement on July 12th if they were already pending, were eligible for immediate dismissal as soon as the law went into effect in late November. And so all of those, to my knowledge, have been all dismissed. There should be no one who has a pending case that would otherwise be eligible for expungement today. In fact, many prosecuting agencies have gone so far as to, even where people are currently serving probation, terminating that probation early and allowing them then to go ahead and file for expungement on July 12th. So the statute in Smart and Safe is codified at Arizona Revised Statute, or ARS 362862. And the law provides that beginning July 12th, 2021, an individual who is arrested for, charged with, adjudicated, or convicted by trial or guilty plea or sentenced for any of the following offenses based on or arising out of conduct occurring before the effective date of this law may petition the court to have that record of arrest, charge, adjudication, conviction, or sentence expunged. So that first paragraph says a lot. First of all, beginning in July 12th, an individual who was, a lot of people might have been arrested, say, for possession of marijuana, but they might not have ever been convicted because, let's say, they did a deferred prosecution. Like some of you have probably heard of TASC. You know, TASC in Maricopa County was an organization that would manage these deferred prosecutions where they'd involve drug testing and drug treatment and so forth. And by completing the program, you would get that your charges dismissed. So it's not a conviction, yet it still shows up on your public record. And so you'd want to be able to get all of that information removed. So that would include the arrest, in that case, the arrest, even if sometimes people are arrested and maybe never charged, but there's still going to be a police record of that arrest. You want to get that expunged. Again, if you did a deferred prosecution, you're going to have an arrest and a charge on your record, accessible by the public. You want to get that expunged. Now, if you were actually found guilty or pled guilty, that's a conviction, and you would have then been sentenced. Obviously, that's on your public record as well. You can get all of that expunged. Then in addition, it's important to note that the conduct had to have taken place prior to the effective date of the initiative, which again, as I said, was in late November. If you, and I'll tell you why that's important here after we go over the different types of offenses that are expungible. Okay, number one, possessing, consuming, or transporting 2.5 ounces or less of marijuana, of which not more than 12.5 grams were in the form of concentrates. So that means any possession of marijuana charge that involved less than 2.5 ounces or less of marijuana is fully expungible. Now, if you also had concentrates with you too, then that's expungible up to 12.5 grams. It's a little more complicated than that, because you can't have had, if you got busted with 2.5 ounces of marijuana and any amount of concentrates, that's not going to be expungible, because you're only allowed to have 2.5 ounces, of which 12.5 grams can be in the form of concentrates. So there's a little bit of a formula there. I don't think it's going to affect a lot of people, quite frankly. So for simplicity, think of it as 2.5 ounces of flour or 12.5 grams of concentrates are dismissible, or I'm sorry, expungible. Secondly, the possessing, using, or transporting paraphernalia. I'm gonna back up. Before we get to paraphernalia. Possessing, transporting, cultivating, or processing not more than 6 marijuana plants at the individual's primary residence for personal use. So this is the cultivation and manufacturing. So cultivation, you can possess the plants, transport them if you were convicted of either of those two things, or cultivating them, which in Arizona is called production of marijuana. That's the cultivation is referred to as production. As long as that didn't involve more than 6 plants, that's fully expungible. Also, manufacturing concentrates from marijuana that you cultivated appears to be also expungible too, although that's less clear. We're going to get to that when we look at a Supreme Court petition form, and I'll tell you why it looks like that's the direction they're going in. But importantly, you'll notice that it says that cultivation has to have been for personal use. So if they're accusing you of growing, 5 plants or 6 plants, and the allegation was that you were going, they might say that they think you were selling, but you're saying no, it was for personal use, then that might result in a need for a hearing, and we'll talk about that procedure coming up. So then finally, possessing, using, or transporting paraphernalia related to the cultivation, manufacture, processing, or consumption of marijuana. So that could be lights, that could be a blasting tube for making wax, that could be scissors for trimming, that could be anything used, obviously a pipe or other smoking or vaping device used to ingest or consume marijuana. All of those different types of offenses are fully expungible. Does anyone have any questions about the offenses involved? What's expungible and what's not? Because, some people I've talked to are, they come to me and they have a conviction for like possession with intent to sell. That would not be expungible. Just possession for personal use would be expungible. I mean, I think there's an argument you could make that possession for sale might also be included. It's certainly, I think, almost certainly going to be denied by the trial court. It might be a good issue for appeal. On some of these issues, I've spoken with the ACLU and attorneys, other attorneys who are interested in maybe appealing some of these issues. But for now, the courts are likely going to say, no, possession for sale is not included. Solicitation, facilitation of marijuana for sale, transportation of marijuana for sale, anything involving sales or intent to sell is not going to be expungible, just for personal use. Does anyone have any questions about any of that?
I
If you would,
did,
okay.
but I wasn't sure how to raise my hand. So is this okay?
Oh, okay. Well, so just for everyone else, there should be like a little hand at the bottom of your screen that you can click if you want to ask a question. I don't know if you can see that, but if not, then just turn on your camera and go like this, and we'll see you. So go ahead, Paxton.
So how do you see, do you just go onto like public access to see if your record is still there, or how do you check that out?
Well, your record is definitely there, even if you can't see it on public access. Not everything is reported on public access, but it would definitely be in like law enforcement database or in a more sophisticated criminal background check that an employer might do. They're still going to be able to see it, even if you're not able to see it on public access. But certainly that's one way to go and try and do some research on your own. If you want to look and see, what you were convicted of, you can look at minute entries for some courts. Not all courts will make their minute entries available, so you can do some more detailed research. You can see exactly what it was that you pled guilty to. One of the limitations of public access is it'll only say what you were charged with. It won't say what you pled guilty to. It might say pled guilty to other charge, but it won't say precisely what it was. If it's in Maricopa County, usually within the last 10 years, you'll be able to click on the minute entries, and you'll be able to usually find the date, the sentencing minute entry, which will specifically say what the offense was. If it's like Navajo County, though, their minute entries, usually you can't see. And so you wouldn't be able to go through public access to try to find that information. Anyone else have any question, or before we move on? All right, great. Okay, so the procedure here is that if the court receives a petition for expungement, then the court will notify the prosecuting agency. Now, if you have an attorney who's filing this for you, the attorney is going to be sending a copy over to the prosecuting agency. If you're filing it, though, if you want to try to do this on your own, then the court would do that for you. The court would send a copy over to the prosecuting agency. And one of the things that you're required to put in the petition, as we'll go over in more detail, is the name of the prosecuting agency, so the court knows where to send it. So they will notify the prosecuting agency, who then has 30 days to respond. So if they don't respond, then in 30 days, the court can go ahead and grant the petition, and likely would, unless there's something that the court sees in its file that suggests that you might not be eligible for expungement. But the state does have the ability to file a response and say, hey, we disagree. This marijuana wasn't for personal use, or this was more than 6 plants that they pled guilty to cultivating. That kind of thing. They can object and say that you're not eligible. And if that happens, then the court would hold a hearing. And at that hearing, the prosecutor has to prove to the judge by what's called clear and convincing evidence that you are not eligible for the expungement. So clear and convincing evidence. It's like in a civil case, usually the the plaintiff has to prove its case by a preponderance of the evidence. So 51% more likely than not. In a criminal case, the prosecutor has to prove its case beyond a reasonable doubt. That's a really high standard. But somewhere in between preponderance of the evidence and beyond a reasonable doubt is clear and convincing evidence. So it's really means very clear, strong evidence that the prosecution is correct, that the petitioner is not eligible. So then the court will, if the court agrees with the prosecutor and says that the court doesn't think that you are eligible, well, then you can then at that point file an appeal to the Arizona Court of Appeals challenging the judge's ruling that you were not eligible. However, if the judge does either grants it because the prosecutor doesn't respond or disagrees with the prosecutor and finds that the state did not prove by clear and convincing evidence that you are not eligible, then they will issue a minute entry, which indicates that that your arrest, charge, conviction, and sentence are all expunged. And if if you were convicted of a felony, if those are felonies and you lost your civil rights, all of those civil rights would then be reinstated as well. Now, on the Supreme Court form, there's a notice that says that even if it's expunged, that you may still have to separately petition to get your gun rights back. I'm not sure why that is. That is that those rules aren't final yet, but it's interesting. So with that caveat about gun rights, all the other rights would be restored and the conviction expunged. The Department of Public Safety is notified by the clerk of court, as well as the prosecuting agency and the arresting law enforcement agency of the expungement. And the clerk will seal all records relating to the arrest, the charge, the conviction, or the sentence, so that they can be accessed only by you, the individual who had the conviction expunged. The Department of Public Safety, that's who maintains all the official criminal history records, would then have to seal and separate the expunged record from its record and then inform all appropriate state and federal law enforcement agencies of the expungement. Now, the Department of Public Safety can charge a fee for that, a reasonable fee, unless you're able to demonstrate that you are indigent, or meaning that you can't afford to pay it. We don't know. They haven't said anything about what kind of fee they might charge, if any, but that's a possibility. There's no filing fee for the petition itself. Let me see here. Also importantly, once it's expunged, that conviction cannot be used against you for any reason. It can't be used against you in like a new prosecution. Like they can't say, oh, you already had a marijuana conviction, so this is going to be worse for you. They can't do that. It can't be like a sentence enhancer. It also can't be used to deny you like a professional license, or that you could be fired from a job or anything like that. It can't be used against you for any purpose. And so that's basically the procedure. The law also, by the way, does allow the prosecuting agencies to file on your behalf. And, I wouldn't hold my breath on any of that, although Pima County Attorney's Office has indicated that it's willing to file some. The Maricopa County Attorney's Office said that if you send them your information, that they will do the research to determine whether they agree that you're eligible for expungement. And if you are, then they'll go ahead and file it. They don't say when they would do that. My guess is that one of the reasons that they're willing to do that might be because they're worried about that 30-day response deadline. Once you file that petition, They have 30 days to do all the research, pull the file, and try to figure out whether or not they should object. If you go to them, they can take all the time they want to review it. And so maybe that might be one of the reasons why they're willing to provide that service. Okay. So do we have any questions right now about the law, the eligible, what convictions are eligible, or what the basic procedure is that we discussed here in the last few minutes? Okay, Karen.
Hi, what is
Hey.
your charge to do the initial background for an individual? To see what the actual charges were and confirm that it's eligible.
How much did you say, how much would I charge?
Yes.
I don't, I haven't really thought about providing like just that service of assisting someone in making that determination. I guess I've thought about what I would charge to do an expungement, and I will get into talking about that towards the end. Okay, so like maybe I'll just hold off on that, and I'm going to get into more detail about that towards the end about what kind of resources that will be available for people to seek here in the next couple of months. So if it's all right, Karen, I'll kind of come back to that towards the end here.
Super, thank you.
Okay, you bet. Ramona, go ahead.
I have two questions. The first one, and I might have missed it. Do I have to wait until July 12th to file the petition if I'm going to do it on my own?
Yes. No, you
Okay.
can't file anything until July 12th.
Okay.
And one of the
Okay.
reasons is because the Supreme Court is working on a form that you would use, a standard form that you would use to file the petition. And that's not available yet anyway, but the court cannot accept any petitions until July 12th.
Okay. Thank you.
Yep.
I also have, he asked me had I smoked that day. I told him, yes, I'm medicated earlier today. So he hit me with a DUI charge. Is that something that I might be able, well,
let me kind of just jump in real quick, and a couple things I would normally tell everybody at the beginning is that obviously, first of all, like anything you talk about, obviously the other participants in the seminar can hear. And so
Right.
there's like, you might want to, everyone just, think about that before discussing your case. And also obviously this doesn't create an attorney-client relationship. This is an informational seminar, but just having said that, I just wanted to remind everybody just in case, but to answer your question, I think is what your question is, a marijuana related DUI is unfortunately not expungible. So we hope in the future that might happen, but under this law, the Prop 207, marijuana DUIs are not expungible. If there is a possession of marijuana charge that went along with the marijuana DUI, the possession charge can be expunged, but the DUI charge would remain. You can still have the DUI charge set aside under the current current law in Arizona that allows a set aside of any criminal conviction. But the problem is it still appears on your public record in most cases, but it will say that the case was dismissed. So if you have a DUI, yeah, that's the best you can do.
Okay.
Okay.
That's what I thought. I just, it is what it is.
Yeah. Yeah.
Thank you.
Yep. Sure. All right. Oh, one more. Okay. All right, Omar, go ahead.
Hello.
Hey.
Two-part question. If you made a plea deal, do they only count that one thing they charge you with, or are they going to look at everything?
They're only going to look at the charge that you were convicted of. So it's an interesting question. As we talked about earlier, you can have an arrest and a charge, a conviction, and a sentence. All of those things are expungible if they qualify. So here's a scenario. You're charged with possession of marijuana for sale, but you end up pleading guilty to the lesser offense of just possession of marijuana for personal use. The conviction for possession of marijuana, you would definitely be able to get expunged, but the charge for possession of marijuana for sale, you probably would not be eligible for expungement. So this is another area that we're going to probably litigate a few issues on, because you can be charged. It's easy to charge someone with anything. You could be charged with possession with intent to sell, but if they're not able to convict you of possession with intent to sell, and you only are convicted of simple possession, then why wouldn't that also be expungible? So I think there's a good argument that even if it started off as something more than one of the offenses that's eligible for expungement, if that's ultimately what happened, I think there's still an argument that you could get those charges dismissed as well. But that is unfortunately not clear yet from anything that we've seen.
Yeah, because you would think, right, that was a deal.
Right.
And
Well,
then
especially you would think that if you like, especially for example, imagine someone gets charged with possession of marijuana for sale. They go to trial. Their defense is, I wasn't going to sell this. This is for my own personal use. And so the jury finds them not guilty of intent to sell, but guilty of possession. So the state has charged him with something they failed to convict him on. Why shouldn't the initial charge also be expungible? So I think there's an argument that it could be, but that may well be something that we have to litigate on appeal. So,
all right, second part question. Do you think we should go ahead and file immediately, or just wait for all that litigation?
Wait for what?
For all that litigation, like you said, for everything to be cleared up,
Yeah, I mean, certainly there's two ways to look at it. One, if you want to be perhaps the person to go up on appeal on the issue, you could be, but that's going to be more time consuming, and potentially if you're paying someone to do that for you, obviously that's going to cost you more money, versus if you do think that you have a conviction that is questionable, or a charge that's questionable, then maybe you would want to just sit back and wait and see how those cases play out. But just so you know, we're likely at least a year and a half away from any kind of appellate decision, because an appeal typically takes about a year. So if you lost your petition at the Superior Court or whatever, and then appealed it, you're talking about a year and a half from now before you're going to start seeing appellate decisions. So you might not want to wait that long. You might want to say, hey, I'll file it. I'll go ahead and go up on appeal. So, it's kind of what you think. If you're patient, then, probably better to watch and see, let someone else be the guinea pig. But if you'd rather get things moving right away, I mean, there's no reason why you can't be the person, the test case.
All right. Thank you.
Mm-hmm. Okay. Anyone else? No? All right, great. So next, what I'd like to talk about is the Supreme Court has created a draft form, and we're going to provide you with this updated form. This is just from a few days ago. This new proposed petition form. It's not the final, it's a draft. The final may be just like this, or that might be slightly different. We don't know right now. It should come out very soon, the final petition form that this Arizona Supreme Court has created. And we'll send you this information, by the way, so that you can look at this form. Just remember, it's not the final form. You can't file this form. This is just a draft form. It says so right on the bottom. It says draft expungement form. So don't try to file this, or it's going to be rejected. All right. So it's a petition to expunge marijuana-related offense records and restore civil rights, including firearm rights. Here's the required information. First of all, it says, I hereby request that law enforcement and court records that the law enforcement and court records for the following offense be expunged. And then you check a box which of the eligible offenses it is. You have the option of choosing either one, possessing, consuming, transporting 2.5 ounces or less of marijuana, of which not more than 12.5 grams was in the form of a marijuana concentrate, or possessing, transporting, cultivating, or processing not more than 6 marijuana plants at my primary residence for personal use. Or finally, possessing, using, or transporting paraphernalia related to the cultivation, manufacture, processing, or consumption of marijuana. Now, you could conceivably have all three of these boxes checked, because if in the same case you had a possession of paraphernalia, possession of marijuana, and like a cultivation of marijuana charge, you'd be checking all three of those boxes, but you check the ones that are applicable to whatever you were arrested for, charged with, or convicted of. That as long as it's all under the same case number, you have to file a separate petition for each separate case number. So the case number goes right in on the top. There has to be a case number included, and that would apply just to that. If you've had more than one time that you've been arrested or charged or convicted, then you have to file a separate petition for each case number in the court where obviously where the conviction or the charges occurred, because most of the possession of marijuana, all of the possession of marijuana charges in Maricopa County are filed in Superior Court. However, some city courts will file possession of marijuana paraphernalia charges. Outside of Maricopa County, most all other counties, they do not file possession of marijuana charges in Superior Court. They're filed in either city courts, municipal courts, or justice courts. So you'd be filing the petition in whatever the court was where you had your case, that's the court that you would file a petition in. The exception to that is if they didn't file charges and you were simply arrested and you want to clear your arrest record, well, then what court do you file in? Because if charges were never filed, how do you know where to file it? Well, in the form, you would file that with the Superior Court in the county where you were arrested, asking to have the arrest record cleared. Okay, so they want you to state here the name of the arresting or citing law enforcement agency. What does that mean, citing law enforcement agency? A lot of times in possession of marijuana, possession of drug paraphernalia cases, there's not actually an arrest, where you're handcuffed and taken to the station. A lot of times people are just given a citation and released. So you have to provide the name of the citing or arresting law enforcement agency. So was it the Phoenix Police Department, the Mesa Police Department, the Department of Public Safety, the Maricopa County Sheriff's Office? So you have to know the name of that. You have to provide the Superior Court case number, or if it's in whatever the case number was, if it was in justice court or if it was in municipal court, you have to provide the case number. And then you have to provide the date, the specific date that you were arrested. You also have to indicate whether your case began in justice court. Now, why would it say that? Outside of Maricopa County, if you're charged with a felony, those cases originate in justice court. So only after there's a probable cause finding is the case then bound over to Superior Court. So in most other counties, you're going to have a court record in both a justice court and a Superior Court if you were charged with felonies. I mean, obviously, a lot of times it's just a misdemeanor charge in other counties. But if it was a felony, you may need to file 2 petitions, one in justice court and one in Superior Court. Or actually, I'm sorry, you would just have to file the one in Superior Court, but you would indicate here whether your case began in a justice court, and if so, you provide the name of the justice court and the justice court case number, and then the court will then make sure that this gets handled over at the justice court as well. So I know might be a little confusing. If it was a misdemeanor charge and it was outside of Maricopa County, it was likely filed either in a municipal court or in a justice court. You would file the petition to expunge in those courts. If it was filed as a felony for some reason in those other counties, it would have originated in justice court, but that's not where you file the petition because if it was bound over to Superior Court. Now, a lot of times, even if it was charged as a felony in justice court, you might have negotiated a misdemeanor deal and it never ended up in Superior Court. In that case, you're filing in justice court, not in Superior Court. But if it made its way over to Superior Court, even if only for a short period of time, then you're filing it in Superior Court and you're telling them whether it originated in justice court. And if it did, then they will notify the justice court to expunge their records as well. I know that's probably might be a little confusing, but that is what it is there. Also you have to provide the name of the prosecuting agency. So was it the Coconino County Attorney's Office? Was it the Arizona Attorney General's Office? Was it the Prescott City Attorney's Office? Basically, those are going to be the three possibilities: either a county attorney's office, the Attorney General's office, or a city attorney's office. Those are going to be the three different prosecuting agencies that would have prosecuted the case. Also, they want to know if you were convicted or not. If you were, so it might have been dismissed pursuant to like a task program, deferred prosecution. But if you were convicted, you have to provide the specific date you were convicted on. And then you also have to indicate if there were any non-eligible charges that were filed against you in the same case. So what does that mean? Well, let's say you got charged with possession of marijuana and possession of cocaine. Well, obviously, they're not going to expunge the possession of cocaine. They would expunge the possession of marijuana. So you have to tell them if there were any ineligible charges that were in the same case. And you don't have to you don't have to tell them specifically what, at least in this draft form, just whether there were or not. You have to also indicate if your sentence included a term of probation. If the case was dismissed, either because you got it dismissed because maybe your Fourth Amendment rights were violated, or because you completed a deferred prosecution like a task program, then you have to specify what specific date the case was dismissed. Also, if you have an outstanding warrant in the case, which might be, I mean, you could have had a case back in October or before November, and maybe they filed the charges and you never showed up. And so there's a warrant for your arrest. Now you can get that expunged, but you got this arrest warrant. You got to get that taken care of too. They have to make sure that gets handled. So you have to indicate whether if do you have an arrest warrant? And then finally, whether there's an active payment plan in your case, because if it's a eligible offense, you don't have to continue to pay on the fine on that. You're not going to get a refund, unfortunately. That would be nice. But if you're still paying, or if you owe money, that's going to be, also expunged. If you were convicted of something more than just like a eligible offense, like let's say, I don't know, you were convicted of possession of marijuana and possession of cocaine, we'll say again, and you're paying a fine on both, you would be able to expunge the marijuana related record and the fine, but obviously you'd still be, if you hadn't paid the fine on the possession of cocaine charge, you'd still have to pay on that. You then also have to, and that's basic information required. Then it says that you don't have to attach supporting documentation, but this Supreme Court form says that the court may find it helpful to have documents that support your request for expungement. For example, the complaint against you, judgment and sentence order, payment plan, or any other official document showing a Superior Court case number, crime lab report showing the weight of marijuana seized, or DPS or FBI case extract. However, you are not required to provide any supporting documents. That's what, again, this is the draft form. We'll see if they decide to require it or not. I don't think they will. Now, you can also request a hearing. I mean, there's no reason to request a hearing. If the prosecution thinks that you're not eligible, they can request a hearing, but so there's no reason that you'd want to request a hearing. And then there's an acknowledgement. You have to acknowledge that even if you get an expungement and your civil rights are reinstated, including firearm rights, you may still be prohibited from having your civil rights restored or your right to carry a firearm under other state or federal laws. So in other words, there may be, just because this order that comes out of the expungement says it reinstates your gun rights and your civil rights, if you have some other felony conviction that's, not an eligible expungible offense, like bank robbery or whatever, aggravated DUI, you're still not going to be able to possess a firearm, even though it's going to state that your firearm rights or your civil rights are reinstated as it pertains to these offenses. If you have some other reason, then obviously you still don't have those rights back. You would have to address that separately in a petition to restore civil rights, which you can do under existing law that's been in place for a long time. So now it does say, when you file this, I declare under penalty of perjury that the information I have provided in this petition and any attachments is true and correct to the best of my knowledge. So if you're filing this, it is under penalty of perjury. And you understand that if you don't provide the required information, the petition will be dismissed. However, you can then refile again with the missing information. If you have an attorney that's helping you, and you don't have to, but if you have an attorney, he signs it saying, to the best of my knowledge, the information provided in this petition is true and correct. So, you want to make sure that you're not just, if you know you're not eligible, then don't file a petition. It could only possibly make things worse by picking up a perjury charge. And so unless you really genuinely believe that you were within the weight limitations, then I wouldn't file it. If you don't know or you can't remember, then you need to do the background research, either yourself or hire an attorney to do that, or one of these private investigator to look into that and figure out whether or not you're eligible or not. All right. The next thing I want to go over, and then we can do some more questions, is the order. What will a court order if you get a petition granted? So I want to say that and this is a new form also. This is a sample order that the court would issue. In this order form, they're saying that after you file the petition, that the court can sign the order if the state doesn't respond in 45 days. I'm not sure why they're saying that, because the state in the law says the law says that the prosecutor has 30 days to respond. Why the Supreme Court is giving him 45 here, I'm not sure. But if the court rules that you were eligible, or that the state failed to prove by clear and convincing evidence that you are not entitled to the expungement, then they would grant the petition, expunge any record of arrest, charge, conviction, adjudication, and sentence, and transmit a copy of the order to the Department of Public Safety, the arresting law enforcement agency, and prosecuting agency, and then further ordered vacating the judgment and conviction and remaining terms of the sentence. So if you're currently serving a sentence, then this would vacate your conviction and any remaining terms of your sentence. So this would mean if you're on probation, you could have probation terminated. If you're in jail, you can get out of jail. If you're in prison, you can get out of prison. I mean, there's still like 100 people in prison right now for possession of marijuana in Arizona. So now what's interesting is that among the various types of offenses that you can have expunged: possession, cultivation, transporting, all of that for personal use. Also manufacturing concentrates. So, or possessing apparently equipment or chemicals related to the manufacturing of concentrates. It appears that although, in my opinion, 207 didn't really clearly state this, it appears, at least in this draft form, that the Supreme Court is willing to allow courts to expunge those types of convictions as well. Again, as long as it wasn't related to like a distribution or an intent to sell. You get all your court-ordered financial obligations canceled, and sealing all of the court records, permitting access in the future only by the petitioner or your attorney. And that's basically what happens when the petition is granted. The next thing I'll talk about is how you can get some help in filing these petitions. But before I go into that, what I'm going to do is get a glass of water, and then I'm going to do some questions with you guys in case you have any questions about anything we've talked about so far. And then we'll talk about where you can get some help, anticipated expungement clinics that'll be opening up, and everything else. So I will be right back in just about 2 minutes, and then we can finish up. All right, and we're back, everybody. So before we finish up here by talking about how you can get help filing a petition, let's find out, is there any questions about anything we've talked about so far? Anyone at all? All right, cool. Everyone's like, no, just tell us how to get help, right? Yeah. So, all right. So in 207, there was $4 million set aside for grant money to be given to qualified nonprofit organizations to assist people in preparing and filing their petitions to expunge. Those applications are all in right now. I don't know how many people filed. I filed through National NORML, the National Organization for the Reform of Marijuana Law is the nonprofit organization. It's been around since 1970. I filed along with Julie Gunnagle, and we're going to involve some other attorneys in Arizona as well, seeking some of those funds. There was also an organization called the Innocence Project, is submitted an application for funds, working in cooperation with the ASU Law School, so that they were going to set up a clinic in the law school, with using the law students to do the work. I think that I think the ACLU, Arizona ACLU, may have also asked for some of the funds. And then I'm imagining that there's probably several other nonprofit organizations that might have filed hoping to get some of that money. Um, for those nonprofits that do receive money, they'll be doing expungement clinics, setting up expungement clinics, and providing expungement for free or at a greatly discounted basis. Um, the I will say though that that amount of money isn't even going to make a small dent in the overall number of eligible records that can be expunged. To give you an idea about that, in the last 15 years, there's been almost 200,000 arrests just for possession of marijuana. All right. So that doesn't count cultivation cases that are eligible. It doesn't count possession of concentrates. It doesn't count possession of drug paraphernalia. Only just relating to possession of marijuana alone in the last 15 years, approximately 200,000 arrests. So if you divide that, if you take those 200,000 people and you divide that into $4 million, you find out that's less than $20 available to process each of those petitions. So it doesn't count those other convictions, and it doesn't count convictions that are older than that. So it's really, I mean, it's sad that there wasn't more money that was devoted to this. There's some discussion about perhaps more money being allocated by either the department or even perhaps the legislature over time to do more expungement work. But there will be those clinics available. Perhaps, as I said, one of them will be one that I am involved in through Normal. And now there will also be, I know there's also people that want to do expungement clinics that are looking for private grants, from other sources. And so and we certainly are going to be, if we get funding from the department, also be looking for additional funding from other grant sources. So, again, you might see some other clinics that operate on that basis alone at a discounted basis or even for free. And then, of course, some people will say, look, I don't have time to deal with one of these expungement clinics. I'm willing to pay a private attorney just to do it for me. And I think that if you do that, the cost of doing that is going to range, I think, vary from attorney to attorney, depending on certain variables like how old the case is, how hard it is to dig up the information. You might have to search the archives and stuff like that if it's old, what county it's in. You're going to look at paying probably anywhere from $750 to $2,500, something like that, to hire an attorney. Again, that depends. If it's a simple case that happened 5 years ago in Maricopa County, then you're probably looking more at like the $750 range for hiring an attorney to file the petition for you. So if that's what you want to do, obviously that will be available to you as well by a number of different attorneys. I'm sure there'll be a lot of attorneys that are thinking of trying to make money on this. And then, of course, you can file it yourself. And, like this seminar, as we get when we get the final rules and the final forms and stuff, I'll still do these seminars, which if you think you want to try doing it yourself, tune in for a future free seminar where you can, learn the latest about how to do these petitions. So that's about all I had for you all today. Again, we will be getting a final rules and forms sometime before July 12th. There's nothing you can file now. You might want to keep an eye out for a future seminar that we'll be doing when those final rules do come out. And I don't know when that's going to be exactly, but it remains to be seen. And obviously, if we get awarded some of that money, that's to set up the expungement clinic. That's something that I'll give you more details about what we're willing to offer there as well. Okay, so does anyone have any questions now at this point before we finish up? All right, going once, going twice. All right, well, hey, everybody, thank you so much. I appreciate you stopping by and spending a little bit of time with me here on a Tuesday. And I look forward to seeing you all again at a future seminar. You know, if you're going to want some updates, or if maybe I'll even work with you in the future and helping you to obtain your expungement. So look forward to that. Thank you.